a representation for the record.
May I praise my Lord? My Lord,
I have listened to the submissions of both counsel. I have perused the affidavits for and against this application. I have also perused the annexures and the documents presented before this court. I wish to state that the purpose of bail is not to free an accused person from any charges that he or she may be facing, but rather to allow a person to stand trial without necessarily being detained in custody during that time. Such a release would also accord the accused the unfettered freedom to prepare for their defense. The Constitution of Uganda guarantees the right to apply for bail in Article 23, 6A. And this right stems from the presumption of innocence, which is enshrined in Article 28, 3A of the same Constitution. The essence and the true meaning of the presumption of innocence as regards bail is that an accused person need not suffer incarceration unreasonably, as he or she is not yet a convict. It is straight law that the court has the discretion whether to grant or not grant bail, but that this discretion ought to be exercised judiciously. This exercise requires a value judgment by the court on whether, in the circumstances of a given case and considering all the factors laid before the court, the applicant would be likely to return for trial if released on bail. The overarching consideration is whether a release on bail would serve the interests of justice, and the rights of the individual to freedom have to be carefully balanced against the interests of the community in addressing crime and being protected from it. Consequently, therefore, courts should lean in favor of and not against the liberty of the accused, as long as the interests of justice will not be prejudiced. I have quoted the decisions, I will not read them out. The main considerations for grant of bail in the High Court are set out in Section 15.4 of the Trial and Indictments Act, and these include whether the applicant has a fixed place of abode within the jurisdiction of the court or is ordinarily resident outside Uganda. Section 15.4a of the TIA, whether the sureties are sound within the meaning of Section 15.4b, whether the accused has on a previous occasion when released on bail failed to comply with terms or conditions of the same, or whether there are other pending charges against the accused persons. Other factors to be considered are set out in the Constitution Bail Guidelines for Courts of Judicature Practice Directions 2022. They include the gravity and the nature of the offense, the antecedents of the applicant, the likelihood of interference with witnesses, and the stage of the proceedings, amongst others. It is not in contention in this application that the applicant has a fixed place of abode at Nantabulirwa Village, Seta Parish, Goma Division, Mukono Municipality, Mukono District, which is within the jurisdiction of this court, where she resides with her family. It is also not in contention that the offense with which she is charged is bailable and that she has the right to apply for bail before this court. Furthermore, the respondent did not contest the applicant's averments that she has a young family and looks after her elderly parents who depend on her for a living, and that she has no previous criminal record or other pending charges. Lastly, I observe that the case against the applicant has already been fixed for hearing, and therefore there is no likelihood of a delay in disposing of the matter at trial. I will therefore analyze and concentrate on the issues that are in contention in this application, and these are whether the applicant suffers from ill health that requires her release on bail, whether from the antecedents of the applicant she is likely to take flight if released on bail, and lastly, whether she has presented substantial sureties before this court to support her application. I will start with the ill health of the applicant. In paragraph 17 of the affidavit in support of the application, the applicant avers that she is sickly, having been diagnosed with severe venous insufficiency, which is a very delicate and life-threatening condition that can lead to sudden blood clot formation, which condition requires specialized medical attention outside of prison. To support this, Annexure D to the affidavit, a medical report made by SP Dr. Muhwezi Julius of the Directorate of Police Health Services, dated 18 April 2023, was tendered in evidence. A consent to the examination by the applicant, witnessed by Detective Inspector Director of Police, Alupo Auna Grace, and duly signed on the same date, was also attached and provided to the court for consideration. From the report on physical examination, she was found to be in a fair general condition with mild anxiety. Her blood pressure was normal. There was obvious swelling involving the entire left foot and the lower 2/3 of her leg, with obvious depression created upon pressing, categorized as grade 2 edema. She did not present difficulty in breathing. She had no cough, no chest pain, or other external injuries. He reviewed her medical documents, which confirmed she is a known patient of severe venous insufficiency, a diagnosis made by a Dr. Kawoya, a radiologist. The radiologist's report was scanned onto his report. It shows mild to severe venous insufficiency on various points on her. In consistency with the condition, a history of fainting following blood clot formation in her lungs, which was resolved, and she's on medication to minimize blood clot formation. The author provides the significance of his findings as follows, and I quote, "Such a patient is a candidate who can develop breathing complications anytime and would need emergency intervention." End of quote. He prescribed the manner in which the patient should be handled while in police detention at Kira Road Police Station. Counsel for the respondent has objected to the report and asked this court not to attach any weight to it on the basis, one, that the technical expertise and experience of the author is questionable, that it was unclear how he came to examine the applicant. He also questioned how the applicant came to be in possession of the report, which is in fact an internal memo between the author and the CID office of Kira Road Police Station. Lastly, he submitted that the findings of the doctor are not reliable, as he did not do any examination of the patient and instead relied on reports authored by other medical professionals. I have carefully considered these objections. I find no reason to doubt the fact that the applicant was examined, indeed, while in detention at Kira Road Police Station by a Dr. Julius Mkwezi, a police doctor, on 18th of April 2023, in the presence of a female police officer. There is uncontroverted proof to that effect. I note that the respondent does not deny the existence of such an officer in the police force, nor that he is a medical doctor, or nor that he is a medical doctor as he asserts in his report. And even in the absence of medical history or his qualifications and experience, the court can safely conclude that the person, Dr. Julius Mkwezi, who examined the applicant, is a qualified medical doctor. I therefore see no reason to reject his report, and I will proceed to analyze his findings in as far as reaching a decision in this matter is concerned. The Directorate of Police Health Services, where he works as a medical officer, is charged with the duty of offering healthcare services to police, staff, their families and suspects while in police custody. He thus booked himself in to assess the applicant's health issues and make sure she accesses the necessary medical support while with them. Review of a patient's medical history is, in my view, always a necessary factor when considering the health of a person. And I see no reason as to why he should have excluded them or not relied on them. I also find no malafide in his decision to examine the minister upon learning that she was in detention at Kira Road Police Station. I'm of the view that the applicant, through her averments in the affidavit and through the annexure report of the medical doctor at Kira Road Police Station, sufficiently proves that she is medically ill and under treatment. And under treatment to avoid reoccurrence of a clot. I'm mindful that in Section 15(3)(a) of the Trial on Indictments Act, proof of exceptional circumstances of grave illness certified by a medical officer of the prison or other institution or place where the accused is detained as being incapable of adequate medical treatment while the accused is in custody is required. I note that we have no report tendered by any other medical officer that controverts what has been tendered by the applicant, including the medical officer of the prison where the applicant is currently detained. I have considered the report of the police doctor made while the applicant was in detention at Kira Road Police Station. In my view, it sufficiently shows that the patient suffers from a condition that is delicate and can be life-threatening and reoccurring, thus requiring keen medical attention. The fact that she is reported to be capable of developing breathing complications requiring emergency intervention, in my view, satisfies the requirements of grave illness within the meaning of Section 15.3a of the TIA. But it should be noted that even in the absence of a medical report within the meaning of the section from a place of detention, the court still deserves the right to grant bail or not bail. In determining the suitability of a surety, the court is enjoined to consider the age of the surety, their work and residence, their character and antecedents, their relationship with the applicant, and any other factors that the court may deem fit. Rule 14 of the Constitutional Bail Guidelines for Courts of Judicature Practice Directions refer. Further, Rule 7 of the High Court Anti-Corruption Division Case Management Rules 2021 provide that the court shall, before considering any person to stand as surety for an accused person, determine that the person has the capacity to A, influence and compel the accused person to attend trial, and B, to meet the terms of the bond. 3 sureties were presented to court. The first surety was Nangoli Edward, MP for Elgon North. His national ID, work ID, and letter of introduction from his area chairperson were tendered in court. He is the chairperson of the Bugisu parliamentary group where the applicant is said to be a member. He was also said to be a long-term friend of the applicant even before their election to parliament. The second surety was Nandalam Nathan Mbafavi, MP for Budadiri County West, Sironko, and chairperson of Bugisu Cooperative Union, former leader of opposition. His work ID, national ID, passport, financial card, and bank statements were deposited with the court. A letter of introduction from the chairperson of the area where he resides was also submitted to court, and 4 land titles were furnished as proof of his financial capacity to pay bond terms and as extra security. The last surety was Amoti Milton Apollo Wangui, LC5 chairman of Bududa district. A letter of introduction confirming his residence was tendered along with a national ID and work ID. He was said to be an anchor to the applicant. Not controvert the fact that the applicant's sureties all have places of residence within the jurisdiction of the court. I will therefore not dwell on this issue. They also did not contest the suitability of surety number 2, Nanda Lambafabi. They, however, opposed the other 2 sureties on grounds that their capacity to compel the applicant had not been demonstrated. It was said that it was not enough that there are people who hold high offices, but their influence over the applicant needs to be demonstrated. It was also submitted they had not demonstrated capacity to pay the bond terms as required under Rule 7 of the ACD case management rules. I have considered the fact that the 2 sureties in question are said to be long-term friend and an uncle to the applicant. They are mature adults, they hold positions of responsibility in the community, one as a member of parliament and another as LC5 chairperson of Bududa district. Additionally, the first surety is the chairperson of the parliamentary group to which the applicant belongs. I am satisfied that by the nature of the relationship of these 2 sureties with the applicant and the positions that they hold, they have the capacity to influence the applicant and compel her attendance of court on dates required if bail is granted. Regarding the capacity of sureties to pay bond in case the applicant absconds, The court has to consider the nature of the offense with which the applicant is charged, including the value of the subject matter. Counsel for the respondent informed the court that the procurement value of the iron sheets was 75,000 per sheet, and that therefore the value of the subject matter is approximately 150 million shillings. I was asked by counsel for the respondent to find the fact that the MP and LC5 are gainfully employed should be sufficient to demonstrate this, considering the value of the subject matter and considering the fact that both the MP and the LC5 are gainfully employed. I agree with counsel for the respondent. I therefore overrule the objection to the sureties, and I find all the three sureties to be substantial. I said in the circumstances of this case and bearing in mind the value of the subject matter. Lastly, whether the applicant is a flight risk. The respondent avers that the applicant is a flight risk. They aver in their affidavit in reply as follows. In paragraph 6, a team was organized to track and arrest the applicant who had refused or declined to avail herself to police. In paragraph 7, that the applicant's telephone lines were placed under surveillance monitoring using the global positioning tracking system, and her phones remained off air up to 15 April 2023. In paragraph 8, it is averred that on the 16th of April 2023, the head of the arresting team and his team went to the applicant's home at Nantabulirwa Seta, Mukono district, in search of the guard that she had not been home since 11 a.m. on the 14th of April 2023. In paragraph 9, it is stated that in the afternoon of 16th April 2023, the Airtel lines of the applicant were switched on. They were then tracked to the applicant's farm at Korasel Mukono, located about 1.5 kilometers from her residence. But by the time of the investigators' arrival, the applicant was not found. The lines were switched off again. In paragraph 10, it is stated that later in the evening of 16th April 2023, at 16:10 hours, the applicant's MTN line was switched on. The investigator tracked it to her home, and when he called it again, it rang in the hands of the applicant's daughter, who disclosed that the applicant had left her with a phone, had not returned since 14th April 2023. That in paragraph 11, the applicant's lines were switched on again when their location was tracked to Kasoko Sokireka. Again, they were switched off. In paragraph 12, it is stated that the applicant had also abandoned her official vehicle at the police headquarters. In paragraph 13 and 14, it is averred that the bodyguard and the driver stated that they had last driven and guarded the applicant on 14th April 2023. Paragraph 15, the respondent avers that on 17th April 2023, the police, through its public relations officer, ACP Enanga Fred, made a public announcement indicating that the applicant was a wanted person. In paragraph 16, it is then stated that the applicant surrendered herself to police at CID headquarters, Kimbui. In rejoinder, counsel for the applicant stated that the applicant voluntarily surrendered herself to police when she learned that she was required, that the state had not demonstrated that she had been formally summoned, and the issues of numbers being off is a mere allegation to which no evidence had been adduced to support. Further states that the information from the driver and the bodyguard cannot be relied on. Again, not substantial evidence had been adduced to that effect. I've considered the submissions of both parties on this issue, and I resolve this as follows. In order to determine whether an applicant is flight risk, court may consider a number of factors. This includes the antecedents of the applicant and their previous conduct, whether or not they had ever been released on bail and failed to report, whether they have family members within the jurisdiction of the court to whom they are obligated, the nature of the work they do, and whether they have sufficient attachments to discourage them from fleeing from the jurisdiction of court. The nature of the charge against an applicant also becomes relevant because a multiplicity of charges or gravity of the charge and possible sentence may also form an incentive for an applicant to abscond from bail. So these are all factors that the court must weigh. I have considered the respondent's concern that when the applicant was needed by police, she became elusive. I note from the affidavit in reply, paragraph 5 thereof, that the applicant had initially been at police because the word return is used. There is no evidence of the circumstances under which she had first gone to police and upon which she was released. Was she a suspect then? Had she been arrested and released on bond? All this is unclear. The opponent avers that it was when she was called and asked to return that she allegedly vanished. It is alleged that Chelimo Biata, Commissioner of Police, is the one who called the applicant using her phone. It follows, therefore, that the conversation that occurred between Chelimo and the applicant can best be relayed by Chelimo herself. Ayebari's averments that the applicant declined to return to CID headquarters is hearsay at best. The evidence adduced by the state, in my view, satisfactorily established the fact that they had difficulty in tracing for the applicant and the suspicion that she had run off to evade the police. It is not stated whether efforts were made to trace the applicant and at her workplace, and that these were futile. The fact that there was difficulty in arresting the applicant then begs the question of whether the applicant knew that she was needed by police in respect of the current charges. And answer to this question is vague. Why? Because I think it is based more on suspicion than fact. The evidence of her surrender is uncontroverted, regardless of the fact that there was difficulty of the police in tracing the applicant. In my view, that surrender mitigates the difficulty that the police had in arresting her. I cannot rush to the conclusion from the evidence that has been presented before the court that she disappeared upon knowledge that she was wanted as a suspect to appear and answer charges in respect of the case. In the absence of formal proof that she was formally summoned and she refused to appear, or that she had been formally arrested and released on bond which she failed to comply with, and coupled with the fact that she handed herself over to the police, I find these factors diminish the likelihood of flight. I have also considered the nature of the offense in issue, the sums involved, the highest penalty upon conviction of this offense of that nature. I've considered that she's a family person with young children to look after. I've considered the issues regarding her medical condition. And having considered all the factors, I'm convinced that the attendance of the applicant can be secured with the imposition of suitable terms if bail is granted to her. That where a court, after considering all factors, is convinced that the attendance of an applicant can be secured with the imposition of suitable terms, then it should be that the appearance of the applicant in this case can be secured by imposing terms, and that the factors in this case lean more towards a grant of bail than a denial of bail. For the above reasons, this court is inclined to believe that the applicant is not a flight risk, and I therefore proceed to grant the applicant bail on the following terms. 1, a cash bail of 10 million shillings by the applicant. 2, each of the sureties is to pay a non-cash bond of 50 million shillings. 3, certificate of title for land comprised in Chagwe plot Block 113, Plot 1649 at Nantabulirwa, and Chagwe Block 113, Plot 1650, also at Nantabulirwa, registered in the applicant's names, shall be deposited with the Deputy Registrar of this court as extra security. The applicant's passport is to be deposited with the court. 5, the applicant is banned from traveling outside the jurisdiction of the country without the leave of court until the disposition of the case. 6, additional security of duplicate title for land comprised in Chadondo Block 224, Plot 844, land at Namugongo in the name of second surety shall be deposited with the Deputy Registrar as additional security. The applicant will continue to answer on the dates that have been assigned to her in the main case. That is the ruling of this court.